Hey everybody, it's Squid. Welcome back to the channel. How is everybody on this effing cold? It was 16 degrees here last night. Like, I know for my northern people that's like par for the course for January, but like down here, that is cold. That's cold anywhere, but that is cold here. And I'm gonna try to get through this relatively quickly because my legs are in so much freaking pain right now. I couldn't sleep last night. I got up at like 4 o'clock in the morning in pain, and there's nothing that can be done about it because it's fibromyalgia, and there's not a whole lot of fucking shit I can do about it. It's because I haven't worked out lately that it's starting to pick up. I'm in that like undertrained or overtrained. You got to hit that sweet spot where you have very little pain, and I'm in that not doing enough and paying for it kind of mode. Hey, how is everybody doing today? Hey, Flash fan, please like, sub, and share. This is an awesome community. I love my chat. I love my mods. Everybody is welcome here, even if you don't agree with me. As long as we're respectful to each other, everybody's opinion is welcome. And I know this topic is particularly dividing. There is people who are like, everything this person does is wrong. And there are people that are on this side that are said everybody on this side is wrong. I am somewhere in the everybody sucks and nobody's perfect. Everybody does things that probably shouldn't have done. Some might be intentional, some might be unintentional. Not my place to judge. Alrighty. Cold and wet, 7 degrees Celsius. Oh, try waking up to 12 degrees in the desert? No, thank you. Yes, and on your way in, smash that like button just once, or make sure it's an odd number. And share this out. I am trying to get to 5K by summer. And speaking of Captain Kern, at 1:30 this afternoon Eastern Time, U.S. Eastern Time for my overseas people, we are going to be talking with Captain Kern, and we are going to go through all the documents in a case that is very, very personal to him. And I will let him share what he wants to share about that when we get there. But 1:30, so I will be back. Let's get into this. This document came out late last night. I was actually doing night court. I was watching the Joseph Ferlazzo case. I had checked it right before I this is not the actual, this is the same document, but I want to share the PDF version. I don't like sharing the window in Chrome. I just don't like it. I like being able to adjust easily the size of my, screen, just like that. Oh, and it's already been a busy morning, so you get like half makeup done, hair in a messy bun. I showered, I did everything, 2 loads of laundry in. It's just a day. It's just a day. I guess when you can't sleep, you got to do something, right? All right. Whoop. All right. This was filed late last night. I got it right after I got done streaming last night, but I was like, I've streamed for almost 3 hours. We're not gonna have the time to do this. So, yay for resizing. I know, right? Yay for resizing a doc. Oh. And I don't have my lights on because like too much. Yeah, it's just so much easier to manipulate, and I like opening it in here because then if I need to redact something, I can redact it versus the when you open it on the screen before you download it or in Chrome, you can't redact it and stuff. Yeah, that was the first thing that I was going to point out. I did the last time I read any documents in this case. I did compare the judge's orders, Shochet's documents, and Bubble's documents, the header. United States District Court of Florida, Northern District of Florida. When you open up anybody else's documents, let's see. I have to open up my what the Hales folder here. I'm going to open up now I know why that looked funny. Judge's order for documents. Let's share this window instead. And I'm just going to compare the judge's order with Bubbles' filings. It says Gainesville Division. Well, with BBB being from Massachusetts, no other place is real to him, probably. So that Joseph Ferlazzo case that I've been watching on Wednesdays, that is out of Vermont. And there is something very interesting about people from up there, personality-wise. And I have Gabby in the chat, and I asked her if it was a North or New England thing, and she's like, no, that's just certain people. Let's they have personalities, all right. Well, everybody has a personality, but some better than others. You notice he leaves the Gainesville Division out. I had somebody comment on a video and say he said that, like, or she had made a comment about, like, it's going to be in Gainesville. Yeah, but you filing a motion for it to move to Gainesville when it's already in Gainesville is a waste of your client's money. Or, if he was charging, I don't know, that's a whole other rabbit hole that we're not going down. Angel, you okay? you She's in the other room throwing things into here. Gainesville doesn't exist to BBB, sort of like footnotes. Always read the footnotes. The footnotes are important. Hey, John. All right. Hales v. Report of 7-1B conference and related efforts to narrow issues and response to plaintiff's motion to compel. Oy vey. Report of conference and efforts to narrow the issue. Upon issuance of the order, document 53, to hold a live phone conference, the conference was scheduled for January 9th at 10 a.m. Counsel conferred on the phone for 90 minutes. They actually talked on the phone for 90 minutes. Okay, we'll see how this goes. Until that conference, defendants did not understand many of the plaintiff's requests given their vagueness and confusing language. We read through that. Did anybody find any of that vague and confusing? Or is that just a Bruce thing? That some called for information in the nature of interrogatories, and some were too unspecific and overbroad to be able to determine what was being requested, making meaningful responses. Yeah. Well, it was in English. There's BBB. Okay. And hey, Melissa Joy, how are you? Yeah. kind of. Yeah, I'm kind of feeling that same thing. Like, unless I see a corroborating report from Randy that said this was also 90 minutes, I'm like, show me some phone records. Just kidding. I'm sure if he said they talked for 90 minutes, they were on the phone for 90 minutes, that doesn't mean they got along for 90 minutes, or that doesn't mean they were talking the whole time. Just that the actual call was 90 minutes. Making meaningful responses problematic. Following the conference, and defendants provided responses to 17 of the plaintiff's 20 document requests. Some responses provided notwithstanding objections. 3 unresolved objections remained. To request numbers that, dude, just write out numbers. Like, you're already writing a 13-page motion. Just write the word numbers. Like, hey, Daryl, probably hard to read due to the size of his nose. That's funny. If Bruce needs a sense of humor, and Bruce, if you're watching, because I know you are, get a sense of humor. Numbers 5, 11, and 12. Following the conference on January 12th, the undersigned emailed plaintiff's counsel. To further narrow the issues, it has been your client's regular practice to show on YouTube any and all of the private communications of my client that he has obtained from any source. Are you willing to stipulate that any private communications, phone numbers, and other non-public information, phone numbers are public information, bro. Sorry about your luck. Will not be shown or read publicly on YouTube or shared with any third parties. If you stipulate, I can determine our position in light of that stipulation. Plaintiff's counsel responded, quote, I will never stipulate to anything that has no basis in the jurisprudence of the world. Stop acting like you're not an attorney. Hey, Radis. Oh. Sorry, I just had to take a pause to let this soak in. Please stop acting like you're not an attorney. Just, oh, bubbles. Bubbles. Oh, boy. On January 20th, in a final effort to resolve the remaining issues on the motion to compel, the undersigned emailed plaintiff's counsel that objections were being dropped to 2, 3, 4, 6, 8, 11, 14, 15, 16, 17, 18, 19. He couldn't, once again, his level of, his skill in writing and writing clearly is like, write out the word numbers. For one, you're a grown-ass man and you're not writing a text. And here, he could have gone 14 through 19, 2 through 4. Like, you could have made this so much easier to read, but he's got to be difficult. Like, I think he does this shit on purpose just to be an ass. And explaining the remaining issues with the other requests. The email concluded, I am available Monday after 10 a.m. and Tuesday until 12 noon for a phone call if necessary. If you would respond by emailing indicating any agreements, we can plan to call to discuss the remaining issues. No response was received. Amended discovery responses were served January 21st, maintaining objections to only 3 requests which are addressed here. Remaining unresolved document requests objections. RFP number 5. All phone records sufficient to show all phone numbers and providers you used during the relevant time period and all documents including mobile phone billing records showing the calls you made or received during the relevant time period relating to the allegations in the complaint or in plaintiff's response in opposition to your motion for summary judgment, including all exhibits attached thereto. The request is not reasonably or narrowly tailored to seek discoverable relevant evidence. All phone records that basically show all the phone numbers, which they do, but he has to be specific, used during relevant time periods. If I were Randy, I would have put a date range from 2021 to now. But so I not to agree with Bubbles, but he's using it something so simple and so all he could do was ask for a date range. He could have asked Randy when they were on the phone for a date range. I get it, but what dates do you want? Because you weren't specific with the all relevant time periods. It's that kind of a, he's got to make this whole long objection for something that could even, well, yeah, and we can actually go back and check that because I have all the documents and I will go back and check that. And on my live this afternoon, I will let y'all know if that was different. I'm actually going to copy this into a different document so that I can actually look. New. There we go. I will we'll look and we'll see if it's the same thing. But he did. Well, I'm just wondering if he put a time period, because the question I would have from Randy, playing devil's advocate, would be a time frame. Like, all relevant time period. What is that time period that you think is relevant? Because that's a subjective, that could be seen as a subjective thing. So if you say all relevant time periods from 2021 till now, then he has to provide everything from 2021 till now. So, yeah, that's just me being nitpicky, because, I didn't write it, and I can be nitpicky because hindsight is 2020. But it is designed to place the defendants to unreasonable burden, and it is classic fishing expedition for evidence in support of claims. Porter v. Ray, 11th Circuit, 2006. While discovery is broad, parties may not engage in a fishing expedition to obtain evidence to support their claims of or defenses. Bruce has been involved much longer than he claims, and this would prove it. Plus, his contract with LMP would be interesting. Yeah. Well, yeah, and that's the thing. Like, the date ranges are specific. I will look it up. I'll actually just look it up now because I'm right here. I'm wondering when that motion to strike, Shochet's response. And I apparently didn't put the dates by it like I should have. Yeah, here we go. I have it. We're going to put the documents side by side. And we are going to look. Number 5. Request number 5. All right, I have to. Let's see. We'll get to it. Sorry, my legs are really bothering me, so I'm like sitting here like trying not to focus. How can the defendants know if a call related to the allegations in the complaint from a call log? It's not the point, you idiot. I'll take care of it. Just DM me on there and let me know what your screen name is, just to make sure I've got exactly the right person, and I'll take care of it. And I have the document open, but it's also a 67-page document, so it's it's a little more difficult to find than just switching documents. But I do have the document open. This request seeks documents obtainable from third parties as easily or more easily than the defendants can obtain them, and or would require the defendants to create documents that do not exist. This I don't understand. If there is no document, then don't provide a document. Yeah. Yes, right here. Like, funny, isn't it? Like, this request would impose on the defendants the burden of going through phone call logs since January 1st, 2020. No, you don't go through them. You just provide them, and it's Shochet's job to go through them. How hard is that? Plus, the more that documents that you hand over, the more time and effort and money it's going to take for Jeremy to get through them. If you're trying to cause harm to Jeremy, then or make it difficult for Jeremy, then that would probably be a good thing on your part, right? Providing call logs and say, here's a stack of, 500 pages. Have fun going through it. When you're looking for one. Yeah, this right here makes me wonder. I'm just wondering if it was just an error, or if it was intentional, or okay, he just gave the wrong date, January 2020, 2021. And somehow knowing which individual calls related to the allegations in this case, which is impossible. That's not your job. That is not your job. That is not your job. That is your job. It is your job to just give over the things and say, here's all the call logs. Have fun. And it's Shochet's job and his team to go through all the call logs and find the relevant stuff. Oh my God. Your Bubbles going through and saying what would be relevant is just dumb. It's just dumb. Like, it would be like me handing the cops evidence against me in some sort of crime. Like, you don't do that. You just give them all the stuff and say, if you want to find it, it's in there. Good luck. And if they don't find it, they don't find it. Like, they can't hand over documents they've already shredded. Well, there's a good point. No, but Eileen BBB's defense, his job is to try avoiding producing anything with the most finely tuned information. Yeah, there's a fine line. A bad lawyer is a person who writes a 10,000 word document and calls it a brief. Very true. Even if just providing the phone logs without identifying specific entries as relating to the allegations, this request would divulge every single phone call the defendants made or received, which would enable plaintiff to call any number to determine who it belongs to and ask whoever name is on the other end whatever he wants about the defendants to use for whatever purpose he wants, such as YouTube content. He always brings up this. Does he understand that he makes most of the YouTube content? Like, he does. Like, most of the stuff that I talk about is just making fun of him. Because it's easy to make fun of him. He just walks right into it. You can't help it. I would feel bad if I didn't take advantage of the situation he granted me. This is a license for him to invade the defendant's privacy and use whatever information he finds for whatever purposes he wishes. There is no reasonable expectation of discovering any admissible evidence, nor the request narrowly tailored for that purpose. The burden of this request outweighs any benefit because the plaintiff cannot explain what relevant evidence he expects to discover through this request. Hi, sweetie. Oh, hi, honey. The defendants further object because the plaintiff's current complaint and the summary judgment opposition collectively contain the totality of alleged statements by the defendant for which plaintiff claims A, defamation, B, extortion, claims to be dismissed, and C, tortious interference. If any are actionable, there would be no need for him to invade the defendant's private communications in search of evidence. There is no apparent connection to any of these claims or the factual allegations underlying them with the request for all communications relating to the plaintiff since January 1st, 2020. Yeah, doesn't even have a timeline, right? For any time period. Nothing the plaintiff can discover in private communications will magically change the non-actionable statements identified in the complaint. I'm just going to bring you. There we go. There you go. You go back. Mama just I didn't want you standing up. In the complaint and summary judgment opposition to actionable ones. Rather, this request is a classic fishing expedition. Porter v. Ray, 11th Circuit, 2006. It's the same thing he brought up before. While discovery is broad, the parties may not engage in a fishing expedition to obtain evidence to support their claims or defenses. Yeah, she's cuddly today. Hugs. You want to say hi? Use your words. Yeah. Mwah. Sweet pea. Go back to. Oh, you just now figured it out? Oh, and we have somebody taking over. No. You always pop it off of there. You do. Do. The defendants further object because, as a public figure, the plaintiff is not entitled to insert into a court document a hodgepodge of statements he finds offensive or are critical of him, but which are not remotely actionable by a public figure, cram them into attenuated legal claims, and then use that as a justification to invade private lives and communications in search of who knows what for his who knows how, although his regular practice is to make YouTube content. Always gotta doxing private communications. That is not the definition of doxing, and bro, you shared the emails that you sent to me. So if you really want to talk about doxing, let's go, bro. Let's go. Like, if emails between people are private information and sharing private information is doxing, bro, you have a lawsuit headed your way because that's exactly what you did to me. I see an ugly ass sword fork poking his snout of an arrow of a gift. Oh my goodness. If you have nothing to hide, then hide nothing. Yeah. Free hugs for all. Those are signs of defamation. And there are things that when you the thing about defamation is when you present it as fact. If you say, this is my opinion, I have no facts to back it up, this is just what I believe, that's different than presenting something as a fact. No. That was... Oh my goodness. No. Here. No. Okay. You want your pad? No. You want? No. Oh, no. Okay. Okay. Go get your pad. Go by Daddy. Yeah, didn't he? Like, oh, y'all are making me laugh this morning. You're the best. The defendants further object because the plaintiff's purpose for this request is to burden the defendants, and the plaintiff's intent and motive to abuse and exploit litigation for ulterior purposes was admitted by him publicly. A lawsuit isn't to win a lawsuit. And he keeps bringing this quote up, but I'm sure, and I didn't see the actual video. I didn't see the video of it. So I can't know, but most of you have seen that video. I'm assuming this was taken out of context and in jest, joking about the amount of money that it's going to cost him to restore his reputation. Yes, he did say it, but what is the context, and what was the tone of voice when saying it? Because a lawsuit isn't to win a lawsuit; it's to prove a point. Like, yeah, it's missing context. That was my point. Like, you can take something out of context and it sound horrible, and then you provide what happened after, what happened before, body language, tone of voice, and it creates a completely different picture. You can already taste the denial BB is going to get over from the judge magistrate. He's already been told he'll be denied all requests. I mean, I just can't, like. And I have people that comment on my videos, like, all of BBB's, all of Bruce's motions have a point. Every time he files a motion that he knows is stupid and is going to get denied, every time he writes a motion that costs his client money. So when he files a motion for nothing, I am not. I just like to follow court cases. I love to read documents, and I just can observe things. So, but I've never claimed to be a lawyer. I've never tried to claim to be a lawyer. I just like to know about our and learn about our legal system, and the best way to do it is by reading documents and watching trials. Yeah. A lawsuit isn't to win a lawsuit. It's to make you spend all your money on a lawyer and bankrupt you. It's what the win is. I could care less or if I win in court. If I win in a court situation, my goal is to make sure you have no money. The goal is, of the lawsuit. RFP number 11, documents sufficient to show numbers of online views and or impressions of any posts of any on your social media accounts, including but not limited to YouTube accounts, Rumble accounts, Twitter accounts, and Facebook accounts during the relevant time period. Uh, it kind of seems that way. It kind of does. Like, I just... uh, Objections. The defendants object because this request places the defendants to burden the screenshotting of every single post since January 21st, 2021 from all of these apps without specifying the single post that, for example, constitutes defamation, extortion, interference, or anything relevant to claims in this case. There is no requirement for the defendants to create documents that do not exist in order to respond to the discovery request, because that would be illegal. Therefore, the burden of the request outweighs any expected benefit. So instead of just saying the documents doesn't exist, he is literally talking about creating documents that don't exist. Like, instead of just admitting that the documents don't exist. And I'm sorry, it is social media. Nothing is ever gone. Like, you can delete something, but that doesn't mean it's gone. Nothing that you put on the internet ever disappears. Just saying. Especially if you have people constantly watching you, watching everything you do. You know somebody's going to archive that crap. This request is not reasonably narrowly tailored to seek discoverable relevant evidence, but is designed to place the defendant in an unreasonable burden and time consumption, and is a classic fishing expedition for evidence in support of the claims. The defendant objects because his burden outweighs any possible benefit. Federal Rules of Civil Procedure 26B1. While discovery is broad, he quotes Porter v. Ray again. Just, we read it twice already. RFP number 12, mobile phone records sufficient to show all phone numbers and providers used between January 1st, 2021. There, he got it right. That's the date you should be using, bro. That is the date that Shochet put. Like, do I think he should have put it in the other ones? I do, but that's just me being nitpicky. Like, yep. Yep. It might not be visible to you, but it's visible to someone. I mean, I wouldn't doubt it. I mean, you can get a Google Voice and you can have multiple Google Voice phone numbers, and it's yeah, this is I'm convinced of right here. He might have taken this case, giving him the benefit of the doubt, because that's what I try to do. But he might have taken this case thinking that she was innocent. David Goliath type situation. However, it's one of those things that after you get some facts and some context and some background, a picture starts to emerge, and it doesn't look good for a certain person. It just doesn't. Like, I don't know. So in other words, they do not want to comply to the request because it makes their case look bad. That's kind of what it sounds like. The art of Google Voice. You can have one phone and 3 phone numbers. Or multiple phone numbers. I have 3. Just saying. So Google Voice is, and then once someone, that's how you get all these spam messages all the time, is you tell them to stop from one phone number, and then the next number you just get put in the next number. Sorry, I'm late. My kid is out of school today, is helping him up with homework. It's always fun. Are you having snow days like we do? Even though I can still see my grass. Like most of the snow melted yesterday. This right here. So Randy did specify a time range in this one relating to the plaintiff by name or otherwise, which means all those like nicknames like Germ and any other thing that they might have called him during that time period. This request is not reasonably narrow, tailored to seek discoverable. Related to plaintiff from how can the defendants, sorry, I lost my place. How can the defendants know if a call related to the plaintiff from a call log? That's not the point. The request, you can't just cherry pick call logs. When they want a call log saying, we want to know if you talked to this certain person, and I'm sure Randy has a list of certain people that he wants, or that he names, which would possibly have been decent to put. They can be. I don't know exactly how that process works, so I can't claim to be an expert in that area, because I know what I know and I don't know what I don't know. But I can imply that phone records can be subpoenaed. I just don't know if Randy needs to do it or how that actually this is true too. The FLP lawyer decided not to provide the records. Just like in the Laura Owens case, when she would not sign the release of the release authorization for her medical records, the judge made her sign it. So the judge can make you do things if they find it reasonable. That's one reason why, even though a certain side decided to drop the thumbnail lawsuit, there's still a hearing on February 5th. There's actually 2 hearings on February 5th. One is at 1 o'clock and one is at 2 o'clock for both cases. So, yeah. And yeah, they have a lot of stuff. I think Bubbles is expecting to play a payday anymore, and he would be satisfied with driving Jeremy to the ground with court costs. All he has to do is drag it out. Yeah, that's part of the problem too. I have a question. Can y'all hear that music? Because the little has her iPad at full blast, listening to music and dancing around the house with Daddy. So, yeah. Oh my God. Oh, and I haven't seen Lori Vallow's Pro Se Motions, but I can almost guarantee that they are far superior to thank you. I just want to make sure that my stream didn't get copyright struck, because my daughter likes to dance and play her music. So appreciate it. Sometimes I don't know what this mic can and can't pick up, so I just want to make sure that I'm not going to get screwed over because somebody in another room. Even if providing the phone logs without identifying specific entries as relating to the plaintiff, this request would divulge every single phone call defendants made or received, which would enable the plaintiff to call any other number to determine who it belongs to, and to ask whoever answers on the other end whatever he wants about the defendants to use for whatever purposes he wants, such as YouTube content. This is a license for him to invade the defendant's privacy and use whatever information he finds out for whatever purposes he wishes. There is no reasonable expectation of discovering any admissible evidence, nor is the request narrowly tailored for that purpose. The burden of this request outweighs any benefit because the plaintiff has not even explained what evidence he believes he will discover that is relevant to proving the claims in this lawsuit. The defendants further object because the plaintiff's current complaint and the summary judgment opposition collectively contained in the totality of alleged statements by the defendant, for which the plaintiff claims A, defamation, B, extortion, and C, tortious interference. If any are actionable, there would be no need for him to invade the defendant's private communications in search of evidence. There is no apparent connection to any of these claims and the factual allegations underlying them with the request for all communications relating to the plaintiff since January. Dude, he put it in there for you, January 1st, 2021, and you still couldn't get it right. Nothing the plaintiff can discover in private communications will magically change the non-actionable statements identified in the complaint and summary judgment opposition into actionable ones. Rather, this request is a classic fishing expedition, Porter v. Ray. We already read it. He's just going to keep saying the same case. Fishing expedition, fishing expedition, fishing expedition. Yeah, this is a bit of a reach. The thing is, like, some things in here I don't necessarily disagree with. It's just he goes a little overboard. Like, if he would have reined it back a little bit, I would agree with some of the things, but he goes too far. And then he just repeats the just because you're on a boat doesn't mean you're on a fishing expedition. That's true too. Ugh. Well, what you said, Squiddy, is BBB. Any evidence provided here is for the purpose of the case. That doesn't necessarily make them public record or useful for anything outside. I see you over there. Oh. The defendants further object, and I think that what's making this so hard to read is it's not double-spaced either. Most legal filings are double-spaced. Like, this is just a book. The defendants further object because as a public figure, the plaintiff is not entitled to insert into a court document a hodgepodge of statements he finds offensive or critical of him. This is literally the same thing. He copied and pasted. This is the same paragraph that was 2 pages back. Like, yeah, this is a rant. Yeah, like that. As the magistrate offered with Jeremy's business info, signing of an NDA could cover some of BBB's stated concerns. That it could. -8. Are you in the northern part of the state or the southern part of the state? Because I got a text message this morning saying that my dad has 4 to 6 inches of new snow at his house. I love some of the names that y'all are coming up. The adult child Bruce, not that one. He's afraid that they will see how long he's been involved and that he solicited her. Yeah. There's the $1 million question, and I can't wait to find out. Ugh. He repeats this. Defendants further object because the plaintiff's purpose for this request is the burden defendant and plaintiff intent to motive. He mentions that same. He copied and pasted this from a page ago. C, response to motion to compel as described in Pilver v. Hillsborough County, Middle District of Florida, August 3rd, 2016. And Hillsborough County is Tampa, Sarasota area. Not Sarasota County, but close. Under Federal Rules of Civil Procedure 26, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. Federal Rules of Civil Procedure 26b1. In determining proportionality, the court considers several factors, including the importance of the issues at stake in the action, the amount in controversy, the party's relative access to the relevant information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs the likely benefit. Federal Rules of Civil Procedure 26b1, information within this scope of discovery does not need to be admissible in evidence to discoverable. Same paragraph. Notably, although the scope of his discovery is broad, he's doing this because he's cherry picking sentences out of the same paragraph, which I would really like to see what that whole paragraph looks, because he's part here, and then B1 is that same paragraph, this part, and then he copies and pastes again this part. So he's cherry picking sentences out of this paragraph. And I would like to see what the whole paragraph says and see what what it actually says in its entirety, instead of cherry picking sentences to meet your needs and to frame your narrative. He tried to be sneaky with it to the average person, but like when you look at it, it's like you keep citing the same thing. It's like, no, because you're cherry picking sentences. That's why. Notably, although the scope of discovery is broad, the discovery rules do not permit the parties to go on a fishing expedition. Porter v. Ray, yet again. Rule 34 only requires production of documents already in existence. Well, the Facebook post would be in existence, right? It's not technically a document, but all you would have to do is print out the page. I mean, yeah. We know that because he doesn't always read footnotes. Footnotes are important. Always read the footnotes. And this judge, when he makes rulings, it's very important to read the footnotes, because he makes rulings in his footnotes. The footnotes is where he spills all the tea. Kaplan v. Kaplan, Middle District of Florida, 2010. Parties served with discovery are not generally required to create documents in order to respond to such discovery, since Rule 34 of the Federal Rules of Civil Procedure only require production of documents already in existence. See Wagner v. SBC Pension Benefit Non-Planned Bargained Program, Barnes v. District of Columbia, and then Sano v. University of Kansas Hospital Authority. Citing Federal Rules of Civil Procedure, Rule 34, noting that a party cannot produce documents that do not exist. Well, I have thoughts. Yeah, call logs are documents that are already in existence, and guess what? So are Facebook posts and stuff like that. I think he is okay. In his twisted mind, he is being a lawyer in this situation and being uber technical. Technically, a Facebook post is not a document like a PDF that you can print out. Like this, page 7. I could print just page 7. But like, he's being technical because Facebook post is not technically a document, but you can screenshot or you can print specific posts. You can go to it on your computer and you can say print screen. Yeah. Yes, JH wants the metadata. Bubbles doesn't understand law regarding digital documents. Well, he is a boomer. Is he? No. Sorry to Gen Xers if he's in your generation, because Cartel Asset Management v. Oshwin Financial Corp. Noting that parties are not required to create new documents to respond to recovery requests, because that's illegal. Like, I'm not sure. That's a very good question. I think did Gen X excommunicate Bubbles once they hate on boomers? Because in general, when you talk about boomers and digital documents and social media, those two have a little bit of difficult time in general. Everybody specific. I don't know. He doesn't understand normal evidentiary requirements. There we go. After all that is imaginary, the web tubes. Yeah, and I think that's what he's getting at. However, he doesn't want to say that. And two, you can still look up the metadata from your old phone. I will be right back. I have to take care of a mommy situation. There we go. We had a table climber.
I'll fix it.
This is also the case. Time and money and there was life before the internet. Sorry, I'm hearing her talk and she's just funny. Rule 34 limits a request for production of two documents which are in the opposing party's possession, custody, or control. Yeah, he really doesn't like he really doesn't get it. And does not require a party to create new documents for production. All you have to do is print. Print. Hello. I take it you're off work another day too. Rule 34 only requires production of documents already in existence. Nether v. $5 Drinkery LLC, Middle District of Florida, 2018. While discovery is broad and the parties may not engage in a fishing expedition, to obtain evidence in support of their claims or defenses. He keeps mentioning this. He's just, you might as well just copy and paste the whole thing because that's all he does. Request, see, and he can't even write out numbers. Like, dude, you wrote 13 pages of BS and you can't write the word numbers. 5 and 12 are fishing expeditions seeking to invade the defendant's privacy and burden. The burden outweighs the benefits. The plaintiff request numbers 5 and 12 both seek 5 years of the defendant's phone call records, showing the calls you made or received during the relevant time period relating to the allegations in the complaint or in plaintiff's response in opposition to your motion for summary judgment, and showing the calls you made or received between January 1st, 2021. That's only 4 years, bro. 4 years. Lawyers can't math. Lawyers can't math. To date, relating to the plaintiff by name or otherwise. Absent a showing of good cause, voicemails, mobile phones, and tablets are deemed not reasonably accessible and need not be searched or collected from in response to a discovery request. See generally Federal Rules of Civil Procedure 26B2B. Requesting party must show good cause to compel discovery of electronically stored information from sources that the producing party shows are not reasonably accessible due to undue burden or cost. Newmark Realty Capital Inc., the BGC Partners Inc., 2018. Well, that's a California case. Plaintiff does not have a generalized right to rummage at will through the motion that the defendant has limited from public view. Palma v. Metro PCS Wireless, Middle District of Florida, 2014. And I'm always interested in these cases against major nationwide companies. C. Smith v. Hillshire Brands, that's another one, 2014, holding that the plaintiff need not produce information from social networking accounts that is irrelevant as defendant is no more entitled to such unfettered access to plaintiff's personal email and social networking communications than it is to rummage through the desk drawers and closets in plaintiff's home. This one I'm not. Exhibit A. I think we've all learned things, and that's one of the reasons that makes this case interesting to follow is not the YouTube part, not the crazy lawyer who I'm really convinced did something to manage to pass this bar exam, but it's interesting as to how it's going to affect digital communications. Is a YouTuber a public figure? It's interesting to see how this is going to affect the YouTube world from going forward. That's kind of why the thumbnail case was kind of entertaining and kind of important too, because you grab pictures for thumbnails all the time. And if that is making, if that is a crime now and you can get sued for that, like every YouTuber on the planet could get sued by anybody else. Like, it's just weird. Like, you know what they call a lawyer who got a D in law school, right? A lawyer. Like, oh, and thank you. Oh, let's go with this. Taz, thanks for the $2 super chat. Can't stay, loves and hugs. Appreciate you. And David, thanks for the $9.99 super chat. Social medias are objectively considered electronic documents. I think that's what he's missing. Is he doesn't I can't get in his brain and I really don't want to, because seems like a scary place. But he doesn't seem to understand that digital posts and things like that are documents. I think this right here is the major disconnect. Yeah, it's good. Or the same for those who took the bar 20 times. I didn't take the bar exam. I'm not a lawyer, but my licensing exam, I only had to take once. And I only had to take once. Let's put it that way. Yes. This I agree with too. This is why JH is doing it so it never happens to anyone else. And I believe just hearing Jeremy talk and how voice, not boastful, it's not the right word, but animated he is when he talks. This kind of makes me think about that quote that Bubbles keeps talking about it's not to win the lawsuit, it's to prove a point. If this kind of is the part of the context of that. Like I said, I didn't see that video, but yeah, that would just be my guess, by someone who doesn't follow Jeremy a lot. It would be impossible for the defendants to look at the last 5 years of dates, times, phone numbers for all phone from. You know why this is so hard to read too? For all phones from every number called or received. Grammar is important. Calls from and check off the ones that are related to the claims in this case or to the plaintiff. Of course, since records of all phone calls are requested, any relating to the plaintiff or his claims would be contained on the call logs, but so would every other call made by the defendants or received from any phone number. And I'm sure that happens in a lot of cases. Like, you're required to turn over your phone records for, say, a criminal investigation, and not everything on there is going to be applicable to what the police are looking for. But you're sorry about your luck to anybody else who you called. Yeah, I think he wants the metadata, because it's all about the metadata, because you can erase something, but that metadata is still there. Nothing goes away. Nothing goes away. Oh boy. Yeah. Other than the plaintiff planning to begin calling numbers and asking whoever answers, "Did you speak to John Cook or Lynette Preston about me?" There appears to be no possible relevance to these requests. The plaintiff has not explained what evidence he believes he will discover that is relevant to proving the claims in this lawsuit. Does he have to? Yeah, that right there. Do you notice, like up here wasn't his 20 or his 7-1B wasn't, but the response to the motion to compel is. So when he went from talking about the Rule 7.1 and his objections, that was single space, which makes me think he had this document typed up with all of his objections, and he just copied and pasted, and he did not even try to format everything the same. So he hodgepodge documents together. Oi. Morning, Yoda. How are you? I'm getting back to where I was. There appears to be no possible relevance to these requests. The plaintiff has not explained what evidence he believes he will discover that is relevant to proving the claims in his lawsuit. If any of the defendant's comments cited by the plaintiff in his complaint or his opposition to summary judgment, all of which was questioned about in his live December 19th deposition, were actionable, there would be no need for him to invade the defendant's private communications in search of evidence. There is no apparent connection to any of the plaintiff's claims in this lawsuit or the factual allegations underlying them. With a request for all phone calls relating to the plaintiff since January 1st, 2020, it's 2021. You're off by a year. Nothing the plaintiff can discover in private communications will magically change the non-actionable statements identified in the complaint and summary judgment opposition into actionable ones. Rather, these requests are a classic fishing expedition. Once again, he mentions Porter B. Ray, and he mentions a couple other cases too. But he basically quotes that same quote. And this is why I'm feeling like I'm losing my place sometimes, is because I feel like I'm repeating myself, like I'm deja vu, big old deja vu situation here. And it's weird. Finally, the burden to the defendants outweighs the benefits. Should they be asked to procure phone logs they don't currently possess, you can get them online. No, I can go right now and get my phone records, and it's not hard. Time consuming, slightly, but not hard. But you actually have to have a computer and a way to print. Or you can just email them. There's no legitimate expectation that phone logs will lead to the discovery of evidence. See Pilver v. Hillsborough County, Middle District of Florida, 2016. In determining proportionality, the court considers several factors, including the importance of issues at stake in the action, the amount in controversy, the parties' relative access to relevant information, the parties' resources. The importance of the discovery is resolving the issues and whether the burden or expense of the proposed discovery outweighs its likely benefit. Emphasis added. Yeah, that's true too. Yeah, that's a good point. No. No, Unhung Hero. Since we are at a breaking point. Thanks for the $25 super chat. Garlic Clove break time, Squid and Squad. Oh my god. He needs Grammarly. Not good with names. He hasn't got a good proofreader. Boy needs Grammarly. Yes, Unhung Hero, thank you for laughing at me. I appreciate you. So, these are the garlic cloves that he is referring to. They're so good, but they are so spicy. Oh. Oh. Thank you, Unknown Hero, for contributing to my grift and making my eyes water. That will warm you up fast. Ugh. Oh, yeah. Touche. Oh, that's spicy. I have Chipotle ketchup. It's really good. It's really good. They're not as hot as they used to be, but they are still kicking my butt. Pepper Palace. It's a store. They have a website. Pepperpalace.com. It's the store that we go to in Charleston every time my friend and I go there. And you literally can grab a spoon and they have all of their sauces in squeeze bottles. And you just go around just tasting everything from barbecue sauces to the spiciest sauce you can think of. Oh. Can't let you do this unpaid. Are you trying to ward off vampires? Well, if I don't know, it's good for pain. Makes me think less about my legs. All right, let's get back into this. We are almost done. We're on page 11 of 13. Request 11 requires creating documents that do not exist and burden outweighs the benefits. The plaintiff wants to learn how many views there were for each and every social media post by the defendant. He doesn't explain how this information is supposed to be provided without creating non-existing documents. It's called metadata. It's called going to Meta and getting the information from Meta. Oh, pickle chips. Oh, pickle chips. Pickle chips. Or ketchup chips. Pickles are the one. I had pickle popcorn one time. Side note. If anybody in Canada wants to send me ketchup chips, I will gladly Venmo you. Oh. Or not pickle chips, ketchup chips. The objection states this would require the defendants to screenshot every single social media post since January 1st, 2021, for all of you who are paying attention, for all these apps, and so the plaintiff could see them and view the numbers. But there is no requirement for the defendants to create documents that did not exist in order to respond to discovery requests. Given the lack of any connection to this request to any of the claims in this lawsuit, the burden of request outweighs any expected benefit. I can't put words in Shocket's mouth, and I don't know. This is my guess. Bruce always mentioned the fact that, well, who saw the signs? How many people saw the signs? How many people saw the signs? So if she made a social media post, and Bruce goes, well, how many people saw it? Here, 100 people saw it. Here, 1,000 people. Even though one is too many, it's the, ooh, hey, Rogue Mama. Dill pickle popcorn seasoning. I like pickles. Don't tell Tug. I like pickles. Oh boy. Given the lack of any connection of this request to any claims in the lawsuit, the burden of the request outweighs any expected benefit. Plus, the plaintiff is capable himself of finding the defendant's post, as he testified in his December 2nd deposition that he canvasses social media every day in search of statements posted by the defendants about him. I mean, that's not entirely wrong. I don't know what that has to do with the laws of discovery, but yeah. I mean, he did say it more than once. He said it in the deposition. In Cornelius v. Rollins Ranches, LLC, Middle District of Florida, January 10th, 2022, the court stated the Southern District found that narrowed requests seeking plaintiffs' bank, phone, text, social media, and email records still appeared to be broad categories of personal records that are irrelevant and disproportionate to the needs of the case. Ugh. On September 29th, 2021, the magistrate judge in the Southern District entered an order denying defendants' request for emails, calls, text messages as irrelevant and not proportionate to the needs of the case. Similarly, in the present case, request number 11 is not proportionate to the needs of the case and does not warrant the burden of the defendants would be placed on in order to respond, including creating non-existing documents. I don't agree with the documents that don't exist, because digital documents are still documents. Facebook posts are still documents. But citing what the Southern District of Florida found, he's got a point. I don't know if it's going to work, but he does bring up at least he uses good case law to cite that. Like, I don't disagree with that point. And I feel weird saying that because it's bubbles, but I call balls and strikes like I see them. I might not be right with my opinion, but Conclusion, thank God. The undersigned made strenuous efforts to resolve the plaintiff's document request and the defendant's objections. The remaining 3 unresolved objections should be sustained for the reasons stated herein. The undersigned respectfully requests any hearing before the ruling on through request objectionability had held via remotely via video or teleconference. Bruce Matzkin. Oh, yoy. So there's that. There's that wonderful little piece of information for this morning. Can I use BPP comply papers for my bird cage? I don't know. Yeah, I see sanctioned in a personal appearance again. I don't disagree with some of the points he was trying to make. I just don't think he did a good job of making the points. And I've learned in life that it's not about the end result, it's about the process. Y'all can come to the same conclusion and get there 2 different ways. It's about how you show the judge how you came to those conclusions, citing the case law, making good points. And I just don't think that he makes good points. Hey, Barbara. That's what you get when you receive your law degree from Cracker Jack Box. He has no clue what he's doing or anything. If it wasn't for the PR team, he'd have absolutely nothing. Mm-hmm. Yeah. I think I am not really sure. It might be, but because this judge is generally super fair, I see some of the points he was trying to make. I don't agree with how he got there, and how he proved his points. I don't think that he proved his points very well. And this is just my layperson's, debate team experience, this part too. And I've said it before, like, I had a high school English teacher that told me when I read people's papers, if I see little mistakes like grammar, wrong year, he looked closer at our papers, because if we didn't pay attention to the easy things, like, I don't know, spelling, then what else did we mess up? What else did we not get right? So when I see spelling, grammar, formatting errors that are simple to fix, it makes me look deeper and dig deeper. And that's why those paragraphs, when I saw him cutting and pasting sentences from that same paragraph, or that same section, it makes me wonder, what else, like, is the case law really cited, and, like, did he cite the case law correctly? Versus if something is formatted great and it's easy to read, my brain doesn't go to what else is wrong here. That's just my yeah, another thing, that this issue has already been ruled on, judge, turn over the evidence. Yeah. Yeah, you cite cases with verbiage to similarities or requests as being not relevant, not just words. Yeah, and it's just, and you can cherry pick case law too. And that's one of the reasons that it takes judges so long to rule on some motions, and they get, 30 days or 6 weeks, or because they go through all that case law and they investigate that case law and they do their due diligence to make sure that case law is actually applicable to the situation at hand, and not just cherry picked. And I've seen from what I have heard about reading motions on a channel that shall remain nameless, they cherry pick things. So if he cherry picks things on social media, why wouldn't he cherry pick things in his career? It's kind of like, it makes me think of, like, if you're willing to do it here, why don't you do it everywhere else? Or do you do it everywhere else? So I need to figure out how to get better at that and get quicker at that. But looking up all these case law, all the case law of what he actually cited. So don't they also verify the case wasn't turned or overturned later? And that's another thing. That's a good point. That's a point I hadn't thought of. Yeah, the Middle District of Florida might have ruled on this, but then it might have went to a higher court, and that court overruled it. So this is what's the problem with cherry picking case law. But I know, because he cherry picked out of that same paragraph of the Federal Rules of Civil Procedure, and he did not cite it thoroughly, or like he didn't cite the whole paragraph. He cherry picked sentences that proved his point. It makes me wonder what else is cherry picked. So, if this client is telling the truth, what is the problem? What are they hiding? And see, it would be different in if it was a criminal case, because if the prosecution requested that they turn over their phone records, they don't have a choice. Like, you have to turn over your phone records. You have to turn over all of your phone records. It doesn't matter if you called Domino's on a Tuesday night. Like, they're going to see you call Domino's on a Tuesday night. That's fine. That's not what they're looking for. So, does anyone know if the depo tomorrow will be in person or with the judge being a plant in video? I would assume it's video, giving people the benefit of the doubt from the start, and the judge this is not his only case. He's got other things to do. So I'm sure he'll give them the benefit of the doubt. It is at either 9:30 or 10 tomorrow. Speaking of tomorrow, I am going 3 weeks. 3 weeks. Yeah. I never hide that I can't type for crap anymore. Thus, I'm not an attorney. Yeah. It's just one of those weird situations that I look at and I'm like, just why? How did it get this far? Speaking of that, if I can get my hands on that deposition transcript, I will be reading it. There's a good chance that I probably won't ever get it, and that's fine. However, if I can read it, I will be reading it. But tomorrow, at about the same time as her deposition, I will be doing a reading documents and getting more information about the what do you want? Oh, my phone. Okay, bye. She took my phone and ran away. I will be doing a deep dive more into the Dr. Joe Corcoran versus HCA Healthcare. That is in Hillsborough County in Florida. Dr. Joe was an expert witness in the Maya Kowalski case. He has a YouTube channel, and he has not made content in a while because he had something big in life going on, and now we know what it is. This lawsuit was filed back in December or November, and there's kind of No, she's being deposed as a witness, not a defendant. So there's a difference. So we will be going over the documents. I read the initial complaint a few weeks ago. However, we will be going over the more of the documents. There's a lot there that I have to sort through. I don't know if it's not enough to make a stream by itself. I will be doing it on Saturday morning updates. But if not, I'm going to get going, and I will see you guys at 1:30 with Captain Kern to go over the documents in his daughter's case. So, yeah, Flea 1 is still a witness to the defamation and means of defamation. She's not a defendant, but she's being deposed as a witness, just like Shara. I will see you guys later. Have an amazing day. I will see you all in a few hours. 3 hours. Bye, guys.